Good day, everyone. So, as a representative of Group 6, I am going to report the case of TORRES versus Courts of Appeals with GR number 134559, promulgated on December 9, 1999. So, before everything else, let us just start with an icebreaker. So, on your screen, that is the general provision of a partnership, which says that by the contract of partnership, two or more persons bind themselves to contribute blank, blank, or blank to a common fund with the intention of dividing the profits among themselves. So, for number 1, for the easiest round, the clues are plus, equals, so men plus a equals money. Alright, so for number 2, for the easier round, we have Pro, iPhone Pro plus rope plus RT equals property. And for the easy round, we have English grammar, in or on. So for the purpose of this game, it's in plus, okay, so kanang allergic ka sa abog, unya abog rapod ka sa classroom. So in English, abog in English is dust, right? So plus RY or RE equals industry. Okay, so I hope you got it all right. For the next and for the average question, so what do you think is the specific article number for this provision? In 3, 2, 1. Okay, so this is from Article 1767 of the new Civil Code. So please take note of the key terms in this provision, such as the money, property, and industry. For these words or terms will be used later on and will be applied in our case. So for the articles, other articles that applied in our case, we have Article 77 as what previously tackled a while ago, and we have Article 1773, which says that a contract of partnership is void whenever immovable property is contributed thereto, if an inventory of said property is not made, signed by the parties, and attached to the public instrument. So let's now go on to the parties of the case. For the petitioners, we have Antonia Torres, assisted by her husband, Angelo Torres, and Emeteria Baring. And for the respondents, we have Court of Appeals and Manuel Torres. So, the facts of the case. Sisters Antonia Torres and Emeteria Baring, the herein petitioners, entered into a joint agreement with respondent Manuel Torres for the development of a parcel of land into a subdivision. Now, pursuant to the contract, they executed a deed of sale which covers that parcel of land, which is in favor of the respondent, who then registered it in his name. So, by mortgaging the property, the respondent obtained from Equitable Bank a loan which, under the joint venture agreement, was to be used for the development of the subdivision. So all the three of them agreed, also as to the share of the proceeds from the sale of the subdivided lots. Later on, the project failed. So the project did not push through, and the land was subsequently foreclosed by the bank. Now, petitioners claimed that the project failed because of Manuel Torres being the respondent's lack of funds or means and skills. Petitioners also added that Manuel Torres used that loan not for the development of the subdivision, but in furtherance of his own company, the Universal Umbrella Company. Petitioners filed the present civil case, which, upon Manuel Torres' motion, later dismissed by the trial court. So it was elevated to the Court of Appeals. However, the Court of Appeals also affirmed the decision of the Regional Trial Court. Now, petitioners strongly denied that they have formed a partnership with the respondent, and they contended that the joint venture agreement and the deed of sale, which were the basis of the court's finding of a partnership, were void, which is pursuant to Article 1773 of the new Civil Code as what they claimed. Which brings to our issue, the first issue, which states that whether or not there was a partnership formed due to that joint venture agreement and the execution of the deed of sale. Now, the court held in the affirmative. The court said that there was a partnership formed since, first, petitioners contributed property in the form of the land, which was to be developed in the subdivision as what they have agreed. Also, on the part of the respondent, he contributed his industry and his money for other costs or expenses. Now, the income from that said project was to be divided according to a percentage which also they have agreed on their joint venture agreement. Furthermore, the respondent cannot be said to have made no contribution to the partnership, since a partner may not only contribute money or property, but also industry, which is in accordance with Article 1767 of the new Civil Code, as what we have tackled on the first part of this video. And for issue number 2, whether or not joint venture agreement is void under Article 1773 of the new Civil Code, which the petitioners claimed. So, the court held in the negative, since first, the Article 1773 was intended primarily to protect third persons. And in this case, it does not involve third parties who may be prejudiced or who may be defrauded. Second is that petitioners themselves invoke the allegedly void contract as basis for their claim that respondents should pay them 60% share of the value of the property. So imagine, on one hand, they want the joint agreement to be void, but on the other, they also wanted to have a 60% share of that value of the property, which the percentage is based on their joint venture agreement, right? So they have conflicting claims. Now, the court said that they cannot in one breath deny the contract and in another recognize it, depending on what momentarily suits their purpose. So parties cannot adopt inconsistent positions in regard to a contract, and courts will not tolerate, much less approve, that kind of practice. Okay, so I hope it was clear, and that ends my report. So this has been Genevieve Bugas with the co-members of Group 6 G1 Paisadas, Rona Beth Cabañas and John Paul Mula. Thank you very much for viewing and for listening. Have a good day, everyone.